Hi guys, this is Liana and today we're going to be discussing civil procedure law in South Africa. This is the first of 3 videos, and in these videos we're going to be handling the pre-litigation, litigation and post-litigation steps of the civil procedure. Now, I'm not going to interrupt myself, I'm not going to pause, so this is going to be like a normal lecture. I'm going to do it from start to finish in one setting. So the pre-litigation phase of civil procedure has everything to do with your client visiting you, telling you what his issues are and what kind of legal advice he wants, and then according to what you determine whether he has a case or not. That's what we're going to be focusing on today. So the pre-litigation phase consists of the following. Firstly, you're going to see, does my client actually have a case? Secondly, does my client have locus standi? Thirdly, jurisdiction issues, in other words, in what court are we going to institute this matter? And fourthly, if the first 3 have been resolved, you're then going to write a letter of demand. So let's start with, does your client actually have a case? The cause of action, that is the term that we use to describe the elements that we need in a civil case for a case to be present. For example, I deal with defamation cases a lot, so I'm just going to use that example. There are elements that must exist before I can institute a defamation case. Firstly, there must be publication of a statement that refers to the defendant, to the plaintiff, and thirdly, that statement that refers to the plaintiff must lead people to question his reputation or to think less of him. That's one example. So each type of civil claim you can institute has elements, and as soon as those elements are present, then your client has a cause of action. So number 1, cause of action, why is my client suing? And are the elements of this certain delict or breach of contract or whatever the cause of action may be, are those elements present? Okay, secondly, we're going to look at locus standi. Locus standi means, do you have standing in the court where you're going to want to be tackling this issue? So a plaintiff will have locus standi, firstly, if he is the right person to be dealing with this matter. For example, if someone drives into my brother's car, I cannot go and be the plaintiff and institute a damages claim on his behalf. He must be the plaintiff. If my company is sued, then they should sue the legal entity, in other words, the company, and not me. So that's your first question when dealing with locus standi is this the right person to be in the position of the plaintiff? Secondly, does this person have the mental capacity to be a plaintiff? Now, when you have mental capacity, it just means that you can understand the legal process and you can participate in it. There are only 4 categories of people who cannot participate. Those are minors, insolvents, prodigals, and then fourthly, those who have been declared insane or unable to handle their own affairs. Let's quickly discuss these. Okay, so minors are not able to act as plaintiffs because they are below the age of 18. And then prodigals are people who have been declared prodigals because they spend their money very recklessly and to such an extent that they cannot handle their own affairs. Insolvent persons can also not litigate, nor can those who have been declared mentally unfit. So if your client is the right person in connection with this case, the right person to sue, and secondly has capacity, then your client has locus standi. So we can then move on to the third consideration, which is jurisdiction. In which court is my client going to tackle this issue? Now, when you look at jurisdiction, you should firstly note some limitations. In a district court, you can only claim for up to 200,000 Rand in damages. In a regional court, you can claim for up to 400,000 Rand in damages. And if the damages exceed 400,000 Rand, you're looking at a high court case. So we have those limitations on the different courts that you can utilize. Then also take note of the following. A magistrate's court, in other words, a district or regional court, cannot deal with will and testament issues and can also not deal with issues that affect a person's legal standing. In other words, if you don't think that someone is able to conduct their own affairs anymore, you can't go to the magistrate court, you must go to the high court. Same if you want to, for example, dispute a will and testament. Now with that in the background, we're going to see how do I determine which court I should sue in. And there are a few elements that we consider in that regard. The plaintiff is called dominus litis. That means the plaintiff is the person who starts the whole legal process, the person who sues. And dominus litis has the right to determine in which court these proceedings are going to be heard. How do we determine that? Firstly, we look at the plaintiff's address, business address or personal address, or where he has property. He can, according to that, he can elect a court. Secondly, we're going to look at the cause of action. Where did the thing happen that led to this litigation? So let's say we had a car crash in Johannesburg, and although I live in Pretoria, I can still then institute action in Johannesburg because the cause of action was there. Also, we're going to look at places where the plaintiff might have immovable property. If you have immovable property in an area, then you can institute legal action in a court in that area. There are a few factors that we can use to determine a court's jurisdiction, and one of them is that the plaintiff can sue in the area where the damage was caused or the area where a dispute started which led to this legal action being taken. Now, apart from those two, the area where the damage occurred and the area where the dispute may have started, the plaintiff can also determine the court in accordance with where the defendant lives or where the defendant has immovable property or where the defendant works. So you can use the defendant's work address or living address or where the defendant has immovable property to determine which court we're going to be using. Why is that? That's because there's a rule that says the plaintiff follows the defendant. So if I'm not going to sue based on where it happened or where the dispute started, then I'm going to sue based on where the defendant lives or works or has immovable property. Okay, so let's quickly summarize jurisdiction. I can choose the jurisdiction as the plaintiff based on where the damage arose or where the dispute started, as well as based on where the defendant lives, his living address, his work address, or where the defendant has immovable property. I must also keep in mind that claims of 0 to 200,000 Rand are typically heard in the district court, can only be heard in the district court. When it goes up to 400,000 Rand, it's the regional court, and claims above 400,000 Rand will be held in the High Court. Lastly, we're going to look at a letter of demand. Before we do that, let's quickly recap. So your client walks into your office. The first thing you're going to ask him is, what is your cause of action? What is it that you want to claim and why? Secondly, you're going to look at locus standi. Is this the right person to be the plaintiff? And does this person have the capacity to act as the plaintiff? Thirdly, you're going to look at jurisdiction. That means you're going to figure out in which court you are going to institute legal action. Once you've made this decision, a letter of demand usually follows. Now, a letter of demand is a letter stating who your client is, confirming that you are representing your client, stating what your client's cause of action is, what the claim is, giving details about why the client is suing. The plaintiff wants to sue the defendant or wants to demand something from the defendant, and then the demand, of course. So let's put this into a practical scenario. You bumped my car in Johannesburg, and we all reside in the Witwatersrand area. That's also where the damage occurred. So I'm going to write you a letter and say, you bumped my car, you owe me money. If you do not pay up within a certain amount of days, I'm going to continue with legal action. So letter of demand is not really part of the litigation process. It precedes it. Okay, because remember, this video is all about pre-litigation. So in the letter, you're going to say, this is my lawyer has the right to represent me, or you as the attorney will say that. You'll say what your client's case is, why he's claiming, what his damages were, why he holds the defendant responsible, how much he wants, and until when the defendant has to pay, for example. Now, it isn't always monetary compensation that they want. Sometimes, once again, I'm going to use the defamation example. Sometimes people write a letter of demand and simply want an apology, and then say, if you don't give me the apology, then I'm going to take you to court. So that is how the process of pre-litigation concludes, is with a letter of demand. I'm just going to recap those elements. Just give me a second. I have my notes with me here because civil procedure is not the easiest thing in the world. In fact, it is quite tricky. Okay, so the purpose of the demand is to inform the defendant that 1, a particular legal representative acts on behalf of the plaintiff. 2, what the nature and the content of the claim is. 3, that payment or performance, in other words a certain act, is requested. 4, the time period that the to-be defendant has to fix, to remedy in terms of what the plaintiff wants. And lastly, the consequences if the prospective defendant does not do so, which usually is that legal action will be taken. So that concludes our pre-litigation lesson, and I really hope that this could assist you. As I explained in previous videos, I don't necessarily have a copy of your syllabus, but I hope to give you some understanding about the civil procedure and to post my next 2 videos really soon.